Sulsa, Secretary General of the Organization of American States, His Excellency Judge Peter Tomka, President of the International Court of Justice, permanent representatives of the member states credited to the Organization of American States, alternate representatives, Judge Kenneth Keith of the International Court of Justice, permanent observers, special guests, friends. I want to start by welcoming all of you to the House of the Americas and to this 54th Lecture of the Americas that we have titled The Role of the International Court of Justice in World Affairs, Successes and Challenges. We extend our greetings also to the audience that is connected via webcast, and also want to recognize our sponsor, the University San Martín de Porres from Lima, Peru. We also want to remind our audience that there is interpretation available for Spanish and English. In today's event, we have the honor to welcome Judge Peter Tomka, who's, as we know, the President of the International Court of Justice, and welcoming here to the House of the Americas. And we are delighted and honored to have him here and have him share his points of views on the role of the court and its commitment to international law and international peace and justice. This lecture is also held on the occasion of the celebration of the centennial anniversary of the Peace Palace in The Hague, which has become a worldwide icon of peace and justice, also for its unwavering commitment to a better world in which conflicts are settled peacefully. We appreciate the presence of our Secretary General, Jose Miguel Insulza, who will be shortly inaugurating and giving some welcoming remarks. His remarks will be followed by a question and answer, by the presentation by our distinguished guest, Judge Peter Tomka. And then we will have a question and answer session moderated by Dr. Jean-Michel Arrigui, who is the OAS Secretary for Legal Affairs. And he is also a member of the Institut of Droit International, and who also will be providing some closing remarks at the end of the lecture. Once we finish here, we would like to invite all of you to a reception that we are going to be hosting in the Patio Azteca in the first floor. I am now honored to give the floor to the Secretary General, Jose Miguel Insulza, for his welcoming remarks.
Thank you very much. It is an honor to welcome the President of the International Court of Justice, Judge Peter Tomka, to this House of the Americas. We also welcome Judge Kenneth Keith from the International Court of Justice, Jean-Michel Arrigui, the Secretary for Juridical Affairs, and the ambassadors and all those that are present. As you know, the International Court of Justice is a United Nations body, a successor to the Permanent Court of International Justice of the League of Nations, but it has, from the beginning, close ties with the Inter-American system. We must remember, too, that it was in our region, in 1907, that the first international tribunal was established. It was the Central American Court of Justice, the first international body in the world on this matter. It ceased operating in 1917, and thought was given to establishing an Inter-American Court of Justice at that moment. Excuse me. And the so-called Peace Code considered that the Seventh International Conference of the American States in 1933 even detailed its rules, procedures, composition, and powers. However, when it became to establishing this international inter-American court, it was decided not to move ahead in this direction because the countries of the Americas were at that time the majority of the universal system. So therefore, felt it was unnecessary to have an inter-American court if we were going to have an international court of justice. The birth of the OAS itself in 1948 was accompanied by the American Treaty on Peaceful Settlement, the Pact of Bogota. And in a sense, that treaty brought the court in The Hague into the inter-American system. The court is a part of the inter-American system also because it very clearly states the possibility of the signing countries that to ask the court to solve their differences where the other forms of peaceful resolution have not been able to solve the case. And several, as I always say, we pride ourselves of being the region that has had less wars in the last century, and at the same time the region that has gone to court at the International Court of Justice more often. Nobody has used the court more than the Latin American countries, and this, I think, is something that we should consider in a positive way. A peaceful resolution is possible, and peaceful settlement of conflicts can be achieved, and when it is not achieved, there's also the peaceful recourse to the International Court of Justice. Several distinguished American jurists have been members of the court, have been president of the court, and just right today we have three OAS members. Members of the court who come from the Americas. Judge Antonio Augusto Cansado Trinidad of Brazil, Judge John Donoghue of the United States of America, and Judge Bernardo Sepúlveda Amor from Mexico. And he is, in addition, the Vice President of the court at this moment. Now, of course, when tribunals hand down a judgment, they may be criticized and they may frustrate the expectations of one of the parties. But fortunately, we all trust, in the end, that its judgments will be complied with in good faith. The final decisions of the court are the results of lengthy processes in which the parties have every opportunity and ample time to expound their points of view and their arguments. Today, it is the vehicle that should enable us to put long-standing difference behind us and focus on the future of friendship and cooperation among our countries. This is a part of the world that, more than any other, has, as I said before, sought to settle its differences by peaceful means. Hence the importance we have always attached to the international tribunals and to respect for international law as, I quote, the standard of conduct of states in their reciprocal relation, end of quote. That's from Article 3 of the Organization of American States Charter. We also hope that to continue using the court. There are a lot of some cases that are there in the court. Some other from some member countries are waiting for the agreement between them to go to court, and we certainly look forward to a fruitful relationship with you in the future. I should also say that we are very pleased to welcome you at this House of the Americas. As I said before, it has something in common with the Peace Palace in The Hague, where the International Court has its seat. Both are funded partially by the same person, Mr. Andrew Carnegie. Was important in the donation for the Palace of Peace, and as you say, very important also for the funding of this building, even though they don't look very much alike. They are not really in a different line of architecture. But please, sir, with this Judge Peter Tomka, we are very also we acknowledge our long legal, diplomatic, and academic career for your country, Slovakia, and we certainly hope that you will succeed, continue having a successful tenure as President of the Court. Make yourself this is your house. This is the House of the Americas is yours, and I'm very proud to give you the floor. Thank you very much.
Dear Mr. Secretary General, Excellencies, ladies and gentlemen, distinguished guests. I am most pleased to be in Washington with you today at the Organization of American States in this beautiful palace. Had the American architect won the international architect competition, we would have a similar building for the International Court of Justice in The Hague. But at the end, the jury selected a project by the French architect Louis Cordonnier, which better fits with the architecture in the Netherlands. I express warm gratitude to the Secretary General, José Manuel Insulza, for his kind invitation to come, and to Mr. George Sanyin, Director of the Department of International Affairs, and his staff, for arranging my visit today. I also take this opportunity to extend my warm greetings to Dr. Jean-Michel Arrigui, Secretary for Legal Affairs, and my confrère from the Institut de Droit International. I'm particularly delighted to be here representing the International Court of Justice, the principal judicial organ of the United Nations, in a time of a great American involvement in the work of the court. It is no secret that the American states have been the most frequent clients of the court since its inception in 1945. The court has also been active in the last 24 years. In fact, the court has rendered more judgments since 1991, some 65 of them, than during the previous 45 years of its existence, some 52 judgments. It is to be noted with satisfaction, and I would say great satisfaction, that the American states have contributed to this positive development by having more frequently resorted to the court as a forum for settlement of the disputes. While during the first 15 years of the court, there were only 4 cases between American states, and in fact, 3 of them concerned the same factual situation. No case was submitted to the court from member states of this organization between 1960 and 1980. Subsequently, some 22 cases in which American states appear on both sides of the aisle in the Peace Palace, that means as applicant and respondent, 22 cases have been brought before the court. Only in the last 15 years, 17 such cases. This clearly illustrates that the court has become a viable option for states in need to assist them in resolving their disputes or to assert their rights, which are being either contested or denied by other states, in particular in situations where negotiations have not led to the satisfactory outcome. The judgments of the court are endowed with the authority of the principal judicial organ of the United Nations, and all UN member states have committed to comply with them under the Charter of the United Nations and the Court Statute, which is an integral part of the Charter. As I said, the Court is currently experiencing and welcomes a particularly Latin American-friendly judicial period. The statistics covering only the last few years are eloquent. Of the 10 cases currently in the Court's docket, more than half, 6, of those proceedings involve disputes between Latin American states. What is more, the Court recently handed down its judgment in the case concerning the maritime dispute between Peru and Chile, and similarly resolved a long-standing maritime dispute opposing Nicaragua and Colombia in November 2012. Up until last September, the Court was also seized of the dispute concerning the aerial herbicide spraying case between Ecuador and Colombia, case with a strong environmental element, which at the end was settled by the parties just 3 weeks prior to the opening of the public hearings in the Great Hall of Justice. In many ways, therefore, my remarks here today will underscore and celebrate some of the many contributions of member states of this organization to the work of the judicial institution based in The Hague. One has to look no further than the bench of the World Court to see the various contributions to its work, if only by way of judicial human resources. For instance, since its inception in 1945, the Court has benefited from the service of 28 distinguished jurists and judges originating from member states of this organization. 6 of these judges went on to become president of the principal judicial organ of the United Nations, while 5 served as vice president. It is in the considerably shorter lifespan of the Court's predecessor institution, because we are successor of the Permanent Court of International Justice, which operated for some 18 years from its inception in 1922. 9 judges originating from Organization of American States served on its bench, including one, Gustavo Guerrero, who later presided that judicial body. Yes, statistics alone do not do justice to the pervasive influence of member states of Organization of American States on the work of the Court. Indeed, the extent and reach of this influence goes much deeper. For instance, it is interesting to highlight the historical contributions of American states in the various conferences and preparatory works that paved the way for the inception of the International Permanent Court of International Justice, and eventually to that of the present-day court, International Court of Justice. While only United States and Mexico were represented at the First Hague Peace Conference in 1899, 19 American states participated in the Second Hague Peace Conference in 1907, out of total of 44 in attendance. In that context, American states contributed greatly to moving the agenda forward, in particular by advancing the following ideas, among others: arguments advocating the non-recourse to force and resort to arbitration for the recovery of contract debts, extensive reliance on the notion of juridical equality of states, especially in connection with the manner of electing judges to different tribunals, and support for the idea of compulsory arbitration, later adjudication. Needless to say, these advances were far from surprising, given the Latin American states have had a long history of agreements and affirmations providing for the peaceful settlement of disputes as between themselves. It is well known that during the initial drafting of the Statute of the Permanent Court of International Justice, I'm mentioning that because the statute of the current court is expressly based on the statute of the previous court, that task was assigned to the Advisory Committee of Jurists, and considerable efforts were deployed to endow the first standing Permanent Court of International Justice with compulsory jurisdiction. In short, while states would have remained unfettered in their choice to adhere to the statute of the judicial institution or not, the acceptance of this instrument would have given jurisdiction to the Permanent Court to adjudicate legal disputes, provided that no agreement had been made to choose another jurisdiction. Ultimately, this proposal did not acquire credence in the Council of the League of Nations, where great powers played an important role. Rather, the prevailing view was that while adherence to the Permanent Court should be actively promoted and enhanced, states should nevertheless retain some degree of discretion in subjecting themselves to the judicial settlement of their disputes. However, I should like to point out that the Brazilian delegate, Raul Fernandes, strongly criticized this lack of compulsory jurisdiction and proposed a compromise which ultimately resulted in the acceptance by delegates of what is commonly termed the optional clause. Thus, the resulting document, the Statute of the Permanent Court, contained a provision which was quite identical to what is now Article 36, paragraph 2 of the present-day Court statute. The actual declaration was actually contained in an optional clause annexed to the protocol of signature, as opposed to requiring states to deposit declarations recognizing the court's jurisdiction as compulsory under a specific provision of the statute. Some have even labeled this provision, which is the genesis of Article 36, paragraph 2 of the present-day statute, the clause Raúl Fernández. The founders of the United Nations system insisted that state consent should remain the cornerstone when electing potential avenues for the peaceful resolution of international disputes arising between member states. This undoubtedly prompted the framers of the Charter to reflect this wide margin of choice afforded states in selecting settlement mechanisms with a view to resolving their differences. In this regard, Article 33 of the Charter provides that, and I quote, "The parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their own choice." End of quotation. It is quite telling that those modes of dispute resolution, along with the OIS corresponding commitment to allowing parties to international disputes to choose their methods of settlement, are mirrored in the charter of this organization, in particular in Chapter 5. Those features of the international system and the corresponding implications for judicial dispute resolution are spelled out in greater detail in Chapter 1 of the Pact of Bogotá. More importantly, this commitment to the peaceful settlement of international disputes also underpins one of the most important jurisdictional instruments under the OIS framework, the Pact of Bogotá, which I will discuss in a moment. In the meantime, suffice it to underscore that the Court itself has acknowledged the importance of peaceful dispute resolution as a driving force behind the adoption of the Pact. In his judgment on jurisdiction admissibility of the application in the case concerning border and transborder armed actions Nicaragua versus Honduras, the Court declared that, and I quote, "It is quite clear from the Pact that the purpose of the American states in drafting it was to enforce their mutual commitments with regard to judicial settlement." End of quote. In short, an unequivocal symbiosis and compatibility exists between the underlying philosophy of the Pact of Bogotá and the ideals enshrined in the UN Charter. The Court's jurisdiction on contentious matters is based on state consent. Simply put, only if parties have consented to the jurisdiction of the Court over the dispute can the Court adjudicate the merits of the case before it. In that regard, a dispute may be brought to the Court in 4 different ways. First, 2 disputing states can conclude a special agreement, commonly referred to as a compromis in French, with the stated purpose of submitting their dispute to the Court. This is by far the most efficient and direct route for electing recourse to the Court. To date, some 17 cases have been brought before the Court by way of special agreement. Some 3 disputes between member states of this organization were brought to the Court via this jurisdictional mechanism, namely the first asylum case between Colombia and Peru in 1949, the dispute concerning the delimitation of the maritime boundary in the Gulf of Maine area between Canada and the United States of America, and the Honduras-El Salvador case in the land, island, and maritime frontier dispute, El Salvador, Honduras, and Nicaragua intervening. Those cases undoubtedly demonstrated the utility of submitting disputes to the Court by way of special agreement. Such agreements enable parties to define the dispute to the Court. The Court is called upon to resolve, to agree on some procedural issues and occasionally even to identify the applicable legal instruments. For one thing, the court is not typically called upon to pronounce on preliminary objections to its jurisdiction or the admissibility of the applicant's claims when a case is brought to it by special agreement. Second, a special provision, commonly termed compromissory clause, granting jurisdiction to the court in respect of disputes relating to the interpretation or application of a bilateral treaty or multilateral convention in which such clause is enshrined, may be invoked by a party to submit a dispute to the court. But usually, prior to the merits phase, the court often has to hear the parties regarding preliminary objections raised by the respondent state to the jurisdiction of the court or the admissibility of the application. We have witnessed a growing number of such compromissory clauses in bilateral treaties and multilateral conventions granting jurisdiction to the court, with currently well over 300 such instruments in force. An example is the case concerning pulp mills on the river Uruguay, opposing Argentina and Uruguay, which culminated in the court's judgment on the merits in April 2010. In that case, the jurisdiction of the court was established on the basis of a compromissory clause contained in a bilateral treaty, namely Article 60, paragraph 1 of the 1975 Statute of the River Uruguay. Third, by way of a forum prorogatum, a state may refer a dispute to the court, knowing that the court does not have jurisdiction initially, but the state invites the other state to accept the court's jurisdiction in that specific case. Should this second state consent to such arrangement, the court is then able to consider the matter. In short, this option enables a state which did not recognize the jurisdiction of the court at the moment when the application instituting proceedings against it was filed to nonetheless accept such jurisdiction subsequently, so that the court may decide the case. A provision to this effect has been included in the Rules of Court, new version, adopted in 1978 under the presidency of Judge Eduardo Jiménez de Arechaga from Uruguay. Fourth, and more importantly for our purposes, a state may make a unilateral declaration by which it recognizes as compulsory the jurisdiction of the court with reciprocal effect on other states. These declarations are made under Article 36, paragraph 2 of the court statute. That said, such declarations may be tailored to fit the needs and interests of those states making them, in particular by determining the scope of the acceptance of the court's jurisdiction or determining the classes or categories of disputes falling within such jurisdiction, or in other way also eliminating certain categories of disputes from the court's jurisdiction's acceptance. In the world of today, when many leaders advocate the rule of law, it is important, in my view, to increase the number of states having subscribed to this jurisdictional avenue. In his report of 2012 for the high-level event on the rule of law, the UN Secretary General called on the UN member states to make declarations recognizing the jurisdiction of the court as compulsory, an initiative that should be welcomed. Moreover, some 7 years earlier, the World Summit Outcome document had similarly called upon states that have not yet done so to consider accepting the jurisdiction of the court in accordance with the statute. However, really considerable work remains to be done on this front. At present, only slightly over a third of the United Nations membership, namely 70 states out of 193, accept the court's jurisdiction under such declarations, including, regrettably, only one permanent member of the Security Council, And this is not satisfactory when we compare this with the situation in 1948, at the beginning of the Organization of the United Nations, when 34 states out of 58 member states accepted jurisdiction, 59%, and this number included 4 out of 5 permanent members of the Security Council. Out of 35 member states of OIS, 14 states currently have optional declarations in force under the Court Statute, a figure representing some 40% of the membership of your August organization. With respect to the jurisdiction of the Court, some regional conventions on peaceful settlement of disputes provide for compulsory jurisdiction, which signatory states accept when adhering to the relevant conventional scheme. For instance, the European Convention for the Peaceful Settlement of Disputes enshrines such a jurisdictional mechanism, and the convention was adopted in 1957. But the pioneering role in this area was played by your organization, and it's more important for our purposes today. In 1948, the American Treaty on Pacific Settlement, known as the Pact of Bogota, was adopted and signed. Its key provision on jurisdictional procedure, Article 31, essentially replicates Article 36, paragraph 2 of the World Court Statute, which, as I pointed out earlier, governs declarations made by states recognizing the court jurisdiction as compulsory. This provision does provide a jurisdictional basis for disputes between the parties to be submitted to the principal judicial organ of the nations for adjudication. At present, the number of ratification accessions made by states under the Pact of Bogota totals 14. Article 31 of the Pact of Bogota has been the foundation of the court's jurisdiction in several cases submitted to it. In particular, out of some 26 disputes opposing OIS member states brought to the court, it is noteworthy that jurisdiction in 13 of these cases was at least partially argued to be based on the Pact of Bogota. Moreover, the court has been called upon to discuss the effect and scope of the Pact of Bogota in 2 cases, thereby providing an analysis of some of its provisions. One such occasion occurred in the above-mentioned judgment on the jurisdiction admissibility of the application in the case concerning border and transborder armed actions Nicaragua versus Honduras. In that case, the court was faced with the possibility of dual basis of jurisdiction, on the one side under the Pact of Bogota, and then on the other, the optional clause under Article 36, paragraph 2 of the court statute. Ultimately, the court did not determine whether Article 31 of the Pact of Bogota constituted a declaration under Article 36, paragraph 1 or 36, paragraph 2 of the court statute, considering it sufficient to highlight that any declaration under the Pact was not subject to reservations made under the optional clause and would need to be modified in accordance with the rules contained in the Pact. More recently, also in the context of its judgment on preliminary objections in the territorial and maritime dispute between Nicaragua and Colombia, the court had to consider whether certain aspects of the dispute of which it was seized had already been settled in the sense of Article 6 of the Pact of Bogota and thus fell outside the jurisdiction conferred upon it under Article 31 of the Pact. Again, the court was faced with the possibility of dual basis of jurisdiction under the Pact and the optional clause. These questions arose against the backdrop of a long-standing dispute which concerned both sovereignty over certain maritime features and the maritime delimitation in the Western Caribbean Sea. Invoking its findings in the border and transborder armed actions case, the court held that the different bases of jurisdiction were distinct and could be wider in one case than in another. Ultimately, the court determined that it lacked jurisdiction regarding Nicaragua's claim to sovereignty over the islands of San Andres, Providencia, and Santa Catalina in view of Article 6 of the Pact of Bogota. This provision states that, and I quote, "The aforesaid procedures may not be applied to matters already settled by arrangements between the parties or by arbitral award or by decision of an international court, or which are governed by agreements or treaties in force on the date of the conclusion of the present treaty." That means the date of conclusion of the Pact of Bogota. As a result, the court opined that sovereignty over the 3 disputed islands had been resolved in favor of Colombia by the treaty concerning the territorial questions at issue between Colombia and Nicaragua, signed at Managua on 24 March 1928, and consequently, the procedures under the Pact of Bogota may not be applied as these matters were settled before the entry into force of the Pact. In other words, by this jurisdictional decision, the court confirmed the sovereignty of Colombia over these 3 specifically named islands and about mentioned 1928 treaty between the 2 parties. Even a cursory glance at the court's docket reveals the profound commitment of member states of this organization to the peaceful and judicial settlement of international disputes. The contribution of Latin American countries have been particularly significant on this front, with a number of states from this region having entrusted their disputes to the court for settlement. By way of example, let me point out a few instances of those contributions in several areas of international law that have been the subject of consideration by the court. One such area pertains to asylum law. In that legal field, some of the earliest cases brought before the ICJ related to a dispute between Colombia and Peru regarding Colombia's decision to grant asylum to Peruvian rebel leader, Mr. Victor Raúl Aya de la Torre, in its embassy in Lima. This decision resulted in strained bilateral relations between Peru and Colombia in 1949 and prompted the parties to seek judicial guidance from the court in resolving the controversy over the application of the rules governing diplomatic asylum, including under the Havana Convention of 1928. As a result, the dispute kept the court rather busy and generated 2 judgments on the merits and a request for interpretation before the disagreement between the parties was finally settled. On the substance of the claims and given the circumstances of the case, the court found that Colombia had failed to comply with the prescription enshrined in the Havana Convention of 1928. This finding hinged primarily on the fact that no reason of urgency could be said to justify Colombia's decision to grant diplomatic asylum to Aya de la Torre pursuant to the convention. That said, to some extent the court returned part of the matter to the parties unresolved, given that the relevant legal principles required them to negotiate a solution in respect of the termination of the asylum. This conclusion stemmed from the court's finding that Colombia had no obligation to surrender Mr. Aya de la Torre to Peruvian authorities, pointing out that the 1928 convention was silent on this point. As a corollary, for the court it followed that, and I quote, "This silence cannot be interpreted as imposing an obligation to surrender the refugee in case the asylum was granted to him, contrary to the provisions of Article 2 of the Convention. Such an interpretation would be repugnant to the spirit which animated the Convention, in conformity with the Latin American tradition in regard to asylum, a tradition in accordance with which political refugees should not be surrendered. There is nothing in that tradition to indicate that an exception should be made where asylum has been irregularly granted. If it has been intended to abandon that tradition, an express provision to that effect would have been needed, and the Havana Convention contains no such provision. The silence of the Convention implies that it was indeed intended to leave the adjustment of the consequences of the situation to decisions inspired by considerations of convenience or of simple political expediency. End of quote from the judgment. Ultimately, an agreement was finally struck by the parties in March 1954 to resolve their disagreements, namely over 5 years after Mr. Haya de la Torre had initially sought refuge at the Colombian embassy in Lima. He had remained in that location this whole time. The agreement reached by the parties provided for the surrender of Haya de la Torre to Peruvian authorities with a view to expelling him subsequently to Mexico, which occurred in April 1954. I would be remiss in addressing your noble organization if I failed to offer a few words on the seminal case concerning military and paramilitary activities in and against Nicaragua versus United States of America. It would probably not be an exaggeration to characterize that case as one of the most important disputes involving American states brought to the court, at least in terms of legal complexity, historical significance, and precedential scope. Similarly, there is no doubt that the court's judgment on the merits constitutes a landmark decision in the broader corpus of international jurisprudence. Since so much has already been written and said about this dispute, my intention is not to add anything further to the voluminous legal, political, scholarly, and journalistic commentary that has already engaged the judgment's legacy. Suffice to say that this dispute provided an opportunity for the court to further develop and clarify international legal rules in several sensitive fields, including the law governing recourse to force and self-defense, the interplay between the court and the Security Council under the United Nations Charter, the scope and content of the principle of non-intervention into the affairs of sovereign states, the distinct coexistence of conventions and custom in international law as sources of international law obligations, and the law governing the international responsibility of states. By way of example, the court made significant advances in the law of state responsibility at a time when the International Law Commission was still far away from finalizing its codification project on the responsibility of states for internationally wrongful acts. In assessing the facts it had to grapple with, the court was called upon to examine the rules governing the attribution of international wrongful conduct carried out by non-state actors to sovereign states. In the context of its analysis, which took place, as I said, against the complex factual backdrop, the court developed a legal inquiry that would become known as the effective control test, thereby clarifying attribution of conduct to a state for the purposes of determining international responsibility. The court's contribution to the law of state responsibility and attribution would later become the foundation for the formulation of Article 8 of the International Law Commission's Articles on Responsibility of States for International Wrongful Act. And this decision and the subsequent work of the Commission were the basis on which the court relied some 19 years later in the case concerning armed activities on the territory of the Congo, Democratic Republic of Congo versus Uganda, and reaffirmed 21 years later in the case concerning the application of the Convention on the Prevention and Punishment of the Crime of Genocide, Bosnia and Herzegovina versus Serbia and Montenegro. Perhaps more importantly, the Nicaragua proceedings before the court undoubtedly cemented that judicial organ's status as a reliable forum in which complex and politically sensitive disputes could be settled peacefully and in utmost independence and impartiality. This precedent also evidences the court's role in furthering the broader objective of maintaining international peace and security, particularly by promoting the peaceful settlement of disagreements in the context of an ongoing armed conflict. It is also interesting to note that some disputes between OAS member states have involved not only national interests for the applicant state, but also rights of its nationals. The case concerning Avena and other Mexican nationals is certainly illustrative of that phenomenon, as it involved questions of life and death. In particular, that case entailed the diplomatic protection of 51 Mexican nationals sentenced to death in the United States as a result of the alleged perpetration of serious crimes on the territory of that state. This case followed a pattern in the court's jurisprudence, particularly the case concerning Vienna Convention on Consular Relations, Paraguay versus United States of America, which was later discontinued on the request of Paraguay, and the Lagrand case between Germany and the United States, in that it highlighted the importance of the provisions of Article 36 of the Vienna Convention on Consular Relations, which seek to protect the rights to consular protection of individuals arrested in a foreign state. It should be stressed that prior to this dispute, in the Lagrand case, the court pronounced on the scope and content of the provisions of Article 36, in particular underscoring that its first paragraph enshrines the individual right to inform his consular office of his arrest and to provide him with consular assistance. Among other important prescriptions, one part of Article 36 provides that if the person arrested so requests, the competent authorities of the receiving state shall, without delay, inform the consular post of the sending state if, within its consular district, a national of that state is arrested or committed to prison or to custody pending trial, or is detained in any other manner. The court in Avena held that this provision gives rise to a duty upon the arresting authorities to give that information to an arrested person as soon as it is realized that the person is a foreign national, or once there are grounds to think that the person is probably a foreign national. Perhaps the most important aspect of the court's decision in the Avena case resides in its engagement with the content of the obligation to provide a review and reconsideration of sentences entered in violation of the Vienna Convention on Consular Relations, which was the case in all these 51 situations involving Mexican nationals. While in principle the United States enjoyed a large degree of latitude in choosing the means to achieve this objective, the court nonetheless specified that the review and reconsideration should be effective and take into account the rights violated. In sum, both the violation and the possible harm suffered had to be fully assessed and considered in relation to both the sentence and the conviction. Moreover, the court indicated that the process of review and reconsideration should be conducted within the overall judicial proceedings relating to the individual defendant concerned. Ultimately, based on the facts of the case, the court concluded that the clemency procedure, as practiced in the U.S. criminal justice system, failed to satisfy the requirements set forth by the International Court of Justice. Consequently, it followed that it was therefore not sufficient in itself to serve as an appropriate means of review and reconsideration as envisaged by the court. It is interesting to note that in 2007, the General Assembly of the OAS referenced the Avena judgment in the preamble paragraphs of a resolution concerning the human rights of migrant workers and their family. Similarly, in a 2009 resolution on the same subject, the OAS General Assembly again referenced the Avena judgment in the preamble paragraphs before later on resolving, among other things, to affirm the duties of states parties under the Vienna Convention on Conciliation Relations and to call to the attention of the states, inter alia, the court's decision in Avena. While the International Court of Justice dismissed Mexico's request for interpretation of its judgment in Avena and other Mexican nationals in 2009, as there was no dispute as to the meaning and scope of the 2004 judgment, the court nevertheless underscored that the obligation to provide means for review and reconsideration is indeed an obligation of result, which clearly must be performed unconditionally. Non-performance of it constitutes international wrongful conduct. I regret that 10 years since the judgment was rendered, the United States have still not implemented it. While President George W. Bush issued a memorandum to the Attorney General expressing the determination that the U.S. government has to discharge its international obligations by having state courts give effect to the ICJ ruling. The President's memorandum was challenged within the U.S. judicial system. In Medellin versus Texas in 2008, the United States Supreme Court, Chief Justice Roberts, writing for the majority, decided that the President of the United States had no constitutional authority to order state courts to the enforcement of the judgment of the International Court of Justice. It also held that neither the Vienna Convention on Conciliation Relations nor the ICJ judgments were self-executing within the U.S. legal order. Therefore, the only way to implement the Avena judgment is the legislation, a legislative act approved by the Congress. Although an act was drafted sometime in 2009, no further legislation has yet been enacted. And none of the Mexican nationals listed in the Avena judgment has so far been given the due and proper reconsideration of his conviction and death sentence, while 4 of them have been in the meantime executed. It is to be hoped that the United States will at the end comply with this jurisdiction and thus strengthen the credibility of its call for rule of law on international plane. It is no secret that some legal disagreements brought to the court often form part of a broader political disputes. In some cases, legal disputes are even brought against the backdrop of acutely precarious transboundary situations, security situations, or military skirmishes. The court can play a role in diffusing tensions between disputing parties in such instances, with the jurisprudence demonstrating the complementary and often mutually reinforcing roles that international judicial settlement and political means of dispute resolution can play in such difficult scenarios. The land, island, and maritime frontier dispute, El Salvador, Honduras, Nicaragua intervening, is particularly apt case in point. It entailed a very active involvement of the Organization of American States, primarily through the pursuit of intense multilateral negotiations with that forum, both before and after the Chamber of the Court delivered its judgment in 1992. Indeed, that case involved extremely sensitive territorial and boundary questions, in particular disputed portions of territory, sovereignty over the maritime features, and disagreement over maritime frontier, and unfolded in the context of highly volatile transborder relations. Thankfully, the Chamber's decision resolved a dispute that had strained the relations between the two neighboring states for over a century, even leading to a 5-day armed conflict between the two states in July 1969. In its judgment, the Chamber of the Court acknowledged that, and I quote, "After 100 hours of hostilities, the Organization of American States succeeded in bringing about a ceasefire and the withdrawal of troops," end of quote. However, the court went on to note that nevertheless the former state of war between the two states was to persist for more than 10 years. Aside from demonstrating complementarity between the OIS multilateral process and the court's judicial process in resolving the dispute, the court's decision also constituted a seminal precedent for the application of the principle of uti possidetis juris and other relevant legal principles applicable to contested territorial title. These rules were again central in the court's reasoning in the subsequent cases involving the OIS member states, particularly in Nicaragua versus Honduras and Nicaragua versus Colombia, which I shall discuss in a moment. First, I come to the territorial maritime dispute between Nicaragua and Honduras in the Caribbean Sea. It is interesting to note the parties' respective claims regarding the shared maritime boundary. And you can see it on the screen. The court rejected the thesis advanced by Honduras as to the alleged existence of a traditional maritime boundary between Nicaragua and Honduras along the 15th parallel. However, the methods of delimitation ultimately selected by the court undoubtedly constitutes the most interesting aspect of this decision. It has long been established in the court's jurisprudence and confirmed in 2009 in a most expressive way in the maritime delimitation of the Black Sea, Romania versus Ukraine case, that the basic maritime delimitation methodology essentially consists of 3 steps. First, the court draws a provisional equidistance line in the area to be delimited. Next, it examines whether that line needs to be adjusted or shifted in the light of relevant circumstances. And finally, the court subjects the adjusted line, if line was adjusted, to disproportionality analysis in order to ascertain whether the maritime areas attributed to each of the parties in the relevant zone are not markedly disproportionate to the length of the respective coasts. In the end, the purpose of maritime delimitation is to achieve an equitable result as stipulated in Articles 74 and 83 of the United Nations Convention on the Law of the Sea, and these provisions are now considered also part of customary international law. Despite initial resistance exhibited by the court in its earlier jurisprudence, the method by which it poses a provisional equidistance line in the area to be delimited before adjusting that line, if necessary, by taking account of special circumstances for the purposes of achieving an equitable solution, ultimately became its preferred delimitation approach. However, because of the particular geographical situation in the Nicaragua-Honduras case, the court resorted to a bisector line as it was unfeasible to construct an equidistance line. The court nevertheless underscored that at the same time the equidistance remains the general rule. Given the instability of the mouth of the river Coco near the Nicaraguan-Honduras land boundary, thereby affecting the position of the appropriate base points to construct the equidistance line, the court discarded the equidistance approach. Particularly challenging was the fact that given the changes in the morphology of the mouth of the river over the years, the coordinates once identified as describing the location of the terminus of the land boundary no longer corresponded to that point. In order to depart from the traditional rule, the court found support in the wording of Article 15 of the United Nations Convention on the Law of the Sea, which it did not interpret as precluding geomorphological problems from amounting to special circumstances and therefore from falling within the purview of the exception laid down in that provision. The court took note of the fact that the parties had raised the possibility of using a different delimitation methodology. Using the bisector methodology, which has taken into account the macro geography of the coastline, the court drew the maritime boundary between the parties and in so doing took into account the various keys that lay seaward of the coast of the parties' territories. In that regard, the court had, before dealing with the maritime boundary, decided that Honduras had sovereignty over Bobble Cay, Savannah Cay, Port Royal Cay, and South Cay on the basis of uti possidetis iuris. Another important and recent case in the court's maritime delimitation jurisprudence is the territorial and maritime dispute between Nicaragua and Colombia. In light of the court's 2007 judgment on preliminary objections, and I already spoke about it, which confirmed that the issue of sovereignty over the islands of San Andres, Providencia, and Santa Catalina has been resolved in favor of Colombia under the 1928 treaty, Nicaragua later adjusted its claims, and you can see it on the sketch on the screen. Nicaragua requested the court to delimit the continental shelf between Nicaragua and Colombia in view of the fact that the natural prolongations of the mainland territories of the parties meet and overlap. In short, Nicaragua was seeking to have the court pronounce on an extended continental shelf in its favor, that is to say, beyond the ordinary 200 nautical mile limit measured from its coast. Nicaragua requested the court to define a continental shelf boundary dividing by equal parts the overlapping entitlements to a continental shelf of both parties. For its part, Colombia requested that the limitation of the exclusive economic zone and the continental shelf be effected by a single maritime boundary constructed as a median line between Nicaraguan fringing islands and the islands of San Andres archipelago. In its analysis, the court confirmed its 2007 conclusion that no maritime delimitation between the parties had been effected by the 1928 Bárcenas-Esguerra Treaty or the 1930 Protocol of Exchange of Ratifications. Thus, the court then applied the usual three-step methodology. First, the court plotted a provisional equidistance line between the parties' relevant coasts, which is now shown on the screen. As you can see from the sketch map, the court selected the base points on Nicaragua's fringing islands and on Colombia's island in and around the San Andres archipelago in order to construct the provisional median line. Turning next to the second step of the delimitation methodology, the court then investigated whether any relevant or special circumstances existed which may have called for an adjustment or shifting of the provisional equidistance line so as to achieve an equitable result. In this regard, the court concluded that the location of the Colombian islands, which lay at an important distance from each other, signaled that the median line between those features and Nicaragua's mainland coast would have effectively cut off Nicaragua from some 3/4 of the area into which its coast projected. Furthermore, the court noted the considerable disparity in the length of the relevant coasts of the parties. Concluding that these circumstances required an adjustment of the provisional median line, the court shifted the line eastward and continued the finalized boundary line out to the line 200 nautical miles from the Nicaraguan baselines along lines of latitude. In the final step of its analysis, pursuant to the methodology laid down earlier in the delimitation in the Black Sea, the court concluded that upon consideration of all the circumstances, the result achieved by its maritime delimitation did not entail a significant disproportionality as to create an inequitable result. This case is significant in the court's broader corpus of jurisprudence because it emphasized the importance of the search for an equitable solution in maritime delimitation matters. In its judgment of 2012, the court held that Nicaragua's claim to an extended continental shelf could not be upheld, primarily on the basis that there had been a dearth of information submitted during the proceedings, thereby precluding the conclusion that Nicaragua had established that it has a continental margin extending sufficiently to overlap with Colombia's 200 nautical mile entitlement to the continental shelf as measured from Colombia's mainland coast, not from the San Andres archipelago islands. The court has taken note with regret of Colombia's government decision to withdraw from the Pact of Bogota. Despite that action, the pact still is to be called Pact of Bogota in accordance with Article 60 of that instrument. In September 2013, Nicaragua introduced new proceedings before the court against Colombia and formulated two requests to the court. One, that it determine the precise course of the maritime boundary between Nicaragua and Colombia in the areas of the continental shelf which appertain to each of them beyond the boundaries determined by the court in its judgment of 19 November 2012. I wish to add that in the meantime, Nicaragua submitted to the Commission on the limits of the continental shelf some scientific information. And the second request, that the court indicate the principles and rules of international law that determine the rights and duties of the two states in relation to the area of developing continental shelf claims and the use of its resources, pending the delimitation of the maritime boundary between them beyond 200 nautical miles from Nicaragua's coast. Moreover, in November 2013, Nicaragua instituted distinct proceedings against Colombia in which it alleges that Colombia has violated several international legal obligations regarding Nicaragua's sovereign rights and maritime zones declared by the court judgment of November 2012. Both cases are currently pending before the court. In February this year, in view of the fact that the parties' coasts generate overlapping entitlements to maritime areas in both the Caribbean Sea and the Pacific Ocean, Costa Rica instituted proceedings against Nicaragua before the court. In that context, Costa Rica asked the court to determine the complete course of a single maritime boundary between all the maritime areas appertaining respectively to Costa Rica and to Nicaragua in the Caribbean Sea and in the Pacific Ocean on the basis of international law. Granted, this new case is only tangentially related to the court's 2012 judgment in the territorial and maritime dispute between Nicaragua and Colombia, but in any event, it should be stressed that the potential rights of third states remained of paramount importance in the court's reasoning. In fact, in 2012, the court emphasized that it has always taken care not to draw a boundary line which extends into areas where the rights of third states may be affected. The judgment by which the court delimits the boundary addresses only Nicaragua's rights as against Colombia and vice versa, and is therefore without prejudice to any claim of a third state or any claim which either party may have against a third state. Perhaps more importantly, the new proceedings instituted by Costa Rica against Nicaragua are historically significant. They constitute the first time ever a state has requested that the court effect a maritime delimitation in areas lying seaward of both extremities of the shared land frontier between the relevant states, in this case in the maritime areas lying in the Caribbean Sea and in the Pacific Ocean. It is also interesting to note that just as a number of the cases involving American states before the court have raised questions of maritime delimitation, these states have played a key role in the development of the current law on maritime jurisdiction. As is well known, the current law allowing states a 200 nautical mile right to the continental shelf and exclusive economic zone was developed after unilateral declarations were formulated by the United States and several Latin American states in the 40s and the 50s. In fact, the existence of declarations proclaiming certain maritime rights extending to a distance of 200 nautical miles on the part of the concerned states and other states in the region was mentioned by the court in its recent decision in January this year in the maritime dispute opposing Peru and Chile. That case also presented a novel factual scenario in respect of the diametrically opposed theses defended by the parties regarding the maritime boundary and whose respective positions now appear on the screen. Peru argued that no maritime boundary had been earlier agreed between the parties. Therefore, in Peru's view, the court should effect a maritime delimitation between the parties in conformity with the usual equidistance relevant circumstances methodology, emphasizing that no such circumstances justified an adjustment of the equidistance line in the circumstances of the Peru-Chile case. For its part, Chile took the view that the entire maritime boundary had already been agreed by the parties, particularly in the 1952 Santiago Declaration, and that it ran along the parallel of latitude, passing through a starting point of the land boundary at the coast out to a distance of 200 nautical miles. Ultimately, on the basis of the evidence submitted to it, the court found that the parties had acknowledged in the 1954 agreement relating to a special maritime frontier zone the existence of a maritime boundary along the parallel of latitude. After examining the entirety of the evidence presented to it, particularly the fishing practice of the parties at that time, the court concluded that the agreed maritime boundary between the parties extended to a distance of 80 nautical miles along the parallel from its starting point, and you can see it on the sketch map. In drawing the undelimited portion of the maritime boundary seaward from the point where the agreed boundary ended, which is depicted as point A on the map on the screen, the court relied upon the three-step delimitation methodology I described earlier. The finalized course of the maritime boundary appears on the screen. I wish to commend both parties, in particular their leaders, presidents, foreign ministers, and ministers of defense, for having, within 2 months from the rendering of the judgment, agreed on the precise geographic coordinates of the maritime boundary on the basis of its description in the court's judgment. In April 2013, Bolivia instituted proceedings against Chile in the case concerning the obligation to negotiate access to the Pacific Ocean. In that pending case, in which Bolivia invokes Article 31 of the PEG of Bogota to found the jurisdiction of the court, Bolivia asked the court to a judgment declare that Chile has the obligation to negotiate with Bolivia in order to reach an agreement granting Bolivia a fully sovereign access to the Pacific Ocean. Then Chile has not yet complied with that obligation. And 3, that Chile must fulfill that duty in good faith, promptly, formally, within a reasonable time, and effectively to grant Bolivia a fully sovereign access to the Pacific Ocean. So the court is not asked to rule on the claim, potential claim to territory, but on the obligation of the parties to negotiate and to reach a satisfactory solution between them. Dear Mr. Secretary General, Excellencies, distinguished colleagues, on the whole, it can be said with confidence that the court has overall played an important and positive role in settling disputes involving member states of this organization. As I have highlighted in this brief survey of cases, Latin American states have been particularly engaged with the court and its work and have entrusted it with a number of important disputes. It is to be hoped that the 6 pending cases involving Latin American states that in these cases, 2 the court's judgment will settle long-standing disputes and thus assist the parties in maintaining and further strengthening their relations. Indeed, the restoration of harmonious relations between states sometimes hinges on the judicial resolution of their disputes by the court. This possibility becomes particularly compelling when seen through the prism of Chapter 6 of the United Nations Charter, which addresses the Pacific settlement of disputes. Thus, the prospect of parties referring their dispute to the court may have a stabilizing impact on their mutual relations or diffuse tensions between them, and feature that often characterizes proceedings before the court. This is particularly true with respect to disputes involving competing claims to sovereignty or maritime zones. In the absence of fruitful avenues of resolution by means of mediation or negotiation, or where creative solutions such as joint management and exploitation regimes may not be devised, recourse to the court remains a viable Pacific settlement option for disputing states. That said, it should be emphasized that the court can play an important role in assisting parties in peacefully settling their dispute prior to rendering a judgment on the merits, even if the proceedings before the court are eventually discontinued prior to the commencement of public hearings. This happened last September in the case concerning aerial herbicide spraying opposing Ecuador and Colombia, with the parties having reached an agreement to settle their dispute to their satisfaction. However, both parties expressed their gratitude to the court for the time, resources, and efforts it had deployed in that case during the period of over 5 years, acknowledging that settlement of the dispute, and I quote, would have been difficult, if not impossible, but for the involvement of the court. Despite the profound commitment to peaceful judicial settlement in the Latin American context, additional efforts must be deployed in order to enhance the compulsory jurisdiction of the court and to promote greater adherence to the Pact of Bogota for those states that have not yet either made a declaration recognizing the jurisdiction of the court as compulsory or have not ratified or acceded yet to the pact. As distinguished and privileged experts working specifically in the field of international relations and international law, you are particularly well situated when advising your respective home states. I also invite you to envisage promoting both dispute settlement by the court and greater adherence to its compulsory jurisdiction as ways to achieve peaceful conflict resolution and more harmonious interstate relations. Indeed, it is to be hoped that more states represented in your distinguished organization will consider recognizing the jurisdiction of the court in the future, be it through compromissory clauses, case-specific special agreements, or by ratifying the Pact of Bogota or via the more general formulation of Article 36, Paragraph 2 declarations. I can see few better ways to effectively reflect the deep and long-standing commitment to international law and the rule of law that a number of American states have already manifested and which were embodied by the eminent judges from the OAS member states that have served on the World Court with distinction. The region covering the membership of your August organization remain absolutely vital to the work of the court and for the progress and advancement of international justice.
Thank you very much, Mr. President, for this very thorough and complete presentation. And now I turn the floor to Mr. Jean-Michel Arrigui to moderate this session of questions, answers, and comments.
It's working. Since the 50s to the 70s, the Latin American country tried to resolve the conflicts or the disputes using a wrong way, the Inter-American Treaty of Mutual Assistance, the TR. Now, in the 80s, they began to use, I think, the good way, that is going through the Pact of Bogota or other treaties by going to the court. And here in that room today, we have two judges of the International Court of Justice, agents and former agents of member states in cases to the court, lawyers in the majority of the cases that you mentioned, former members of the International Commission of International Law and on the Inter-American Juridical Committee, ambassadors of member states of the OAS and ambassador to the US. That is maybe the proof that that is the way that the Americas are now dealing to resolve their conflicts. And I'm sure, because there is full of young lawyers and professors, that they will have a lot of questions for you. Les quiero aclarar además que hay traducción español-inglés, así que siéntanse libres de hacer preguntas en español o en inglés. Y si hacen en francés o en portugués, yo ayudo con la traducción. No sé si hay... Is there... please identify you for the internet transmission. No sé.
Gracias. Gracias, señor presidente. Soy Daniel Pacheco de Caracol Televisión de Colombia. Quería preguntarle por sus comentarios sobre la denuncia al Pacto de Bogotá que hizo el presidente Juan Manuel Santos y si piensa que esto establece una tendencia más amplia de pérdida de jurisdicción de la Corte en América Latina. Muchas gracias.
If we want, we can take 2 or 3 questions and then, si hay alguna otra pregunta, a ver.
Buenas tardes, señor presidente. Muchísimas gracias por esta presentación. Mi nombre es Andrés Pulgar, soy pasante de acá de la Organización de Estados Americanos. Mi pregunta va relacionada en torno a una discusión que se ha planteado en el orden público actual sobre el poder que tienen las organizaciones internacionales y la Corte para hacer aplicables sus decisiones. Esto en base al Jus Cogens, que sabemos que principio que rigen todos los tratados, y es que se ha hablado específicamente en institutos alemanes sobre una especie de soberanía internacional que maneja la Corte y que manejan las organizaciones internacionales para hacer aplicables estas decisiones. Quisiera preguntarle específicamente qué opinión le merece este término, soberanía internacional, y en base a esto relacionar cómo pudiese este término aplicarse a organizaciones como por ejemplo la Organización de Estados Americanos, la ONU y la propia Corte Internacional de Justicia. Muchas gracias.
No, ahí atrás tuyo, pasa el micrófono.
Sí, gracias. Iván Chanes, de la Misión de Panamá. De todo, muchas gracias por su presentación, ha sido muy interesante y agradecemos estar aquí. Siendo el título de la lectura Successes and Challenges de la Corte, siendo la región americana una de las que más ha acudido a la Corte, pero a la misma vez teniendo 3 al menos casos en que el hemisferio no ha cumplido, no está por cumplir decisiones de la Corte. Depende de interpretación, sabemos que pueden haber más. ¿Cuáles serían esos desafíos para nosotros? O sea, como internacionalista y dejando la política, la diplomacia a un lado, el respeto del derecho internacional, en este caso, sentencias de la Corte Internacional de Justicia, teniendo casos y muy recientes en el hemisferio, le caerían cualquier nivel de preocupación a quienes somos estudiosos del derecho, a quienes creemos en el sistema internacional, tanto de los derechos humanos como de las responsabilidades de los estados ante estas cortes y organismos. Entonces, si puede darnos un poquito más de sus impresiones en cuanto a esos challenges, esos desafíos que en este caso el hemisferio está afrontando por X o Y razones, sin entrar en detalle de los casos. pero en cuanto al respeto en sí del derecho internacional. Muchas gracias.
Do you want to respond?
Thank you very much. Several questions. The biggest challenge for the court is to move from a system which was devised 100 years ago, which is based on state consent. The international community has developed, there is more cohesion in the international community. There are calls for rule of law, but in my view, a rule of law would be the concept incomplete if there are no courts for asserting your rights. I'm not saying that the first avenue for resolving dispute is to go to the court. No, it should be the last one. Disputes should be primarily resolved through negotiations or mediation, because reaching agreement means that the states can live with the compromise solution they achieved. You see in different parts of the world tensions, competing claims to either sovereignty, maritime delimitations. Some of these states are telling that they wish to resolve that through negotiations, but what kind of negotiations they lead if within 30, 40 years they are not able to resolve such a dispute. And the court in several of its decisions said that negotiations not only have to be led in good faith, but also in such a way that negotiations should be meaningful, and that would not be the case if each party, each side insists on its own positions. There is a need for some compromises, because only then agreement can be reached. But if the agreement cannot be reached, there should be a forum where rights, claimed rights, can be asserted. So I think that's the challenge. We have still a long road to go in order to have what is idealistically called upon and subscribed many leaders when they meet in New York and adopt these great declarations like World Summit Outcome document, or in 2012 on rule of law. They support that idea, but that idea has to be implemented through practical steps, really strengthening rule of law, not only domestically, but also on international plane. So while sovereignty is certainly important, and so far this has had implications on the court's jurisdiction that there is all the time needed the consent, my appeal is that states should really consider to accept the court jurisdiction more broadly under certain circumstances. The fact that we don't have overall general jurisdiction in relation to all member states of the United Nations, but only in case of declarations or cases of compromissory clauses, leads to a situation that sometimes states then frame their dispute in terms of a dispute under a particular convention. But clearly what is behind is something else. But as there is no jurisdiction under declarations, then they discover, well, there is this multilateral convention, so maybe one element of the dispute could be presented as a dispute under that multilateral convention from, for instance, the field of human rights. Our court, as you know, is the court for only states. We have no jurisdiction concerning the individual applications, although we receive a number of individual complaints from people unhappy with the decisions of their governments, the denial of their rights. We have just to inform them that under Article 34 of the Statute of the Court, the access to the court is only granted to states which are parties to the court statute, that means member states of the United Nations. In a situation where there were some states which at a certain moment they were not members of the United Nations, they could have asked for granting access, and the General Assembly adopted appropriate resolutions. That was, for instance, the case for Switzerland or Liechtenstein before the admission to the United Nations. It may happen that occasionally, following the court's decisions, the state decides to terminate the acceptance of the court's jurisdiction, either by terminating the declaration. That happened in 1961 when Thailand terminated the declaration once the court upheld its jurisdiction in a case brought by Cambodia relating to the sovereignty of the Temple of Preah Vihear. Or France in the 70s when Australia and New Zealand brought a case, two cases concerning the same issue, nuclear tests in the Pacific, in the atmosphere. Or sometimes it may happen that the state terminates membership in a regional convention on peaceful settlement of disputes. That's regrettable, but the court always considers very carefully the evidence submitted to the court, and in impartial and independent way try to apply international law in a way in order to render the justice, and in terms of maritime delimitations to achieve equitable solution. And you can see these solutions when the court, for illustrative purposes, provides a map or sketch. And the decision which led to the termination of the Pact of Bogota by one of states was adopted unanimously by 17 judges, 15 elected members of the court, and 2 ad hoc judges appointed by the respective parties. Because in our court we have, in addition to elected members, elected by the Security Council and General Assembly, also judges ad hoc appointed by the parties, but the national is not in the court. And this is due to the fact that international judicial proceedings evolved from international arbitration. So I do not know whether I answered all questions. I tried my best. At the very beginning, I had some problems to find the appropriate channel to understand well the question which was put in Spanish.
No, but that was the answer.
I'm not trying to avoid any question.
¿Hay más preguntas? A ver.
Good afternoon, Your Excellency, Mr. Secretary. I'll try to keep my question brief. First of all, of course, I would like to welcome you and thank you for your time. In my case, I would like to posit the challenges that the court faces as a guardian of territorial integrity nowadays. We see everywhere in the world situations in which certain portions or regions of countries are trying to break away from their own states and trying to form sub-sovereign units. And so, of course, this leads to the entire state of affairs nowadays that asymmetric warfare makes any sort of mediation efforts all the more difficult in the leadership in these sub-regions. It comes to mind the case of Nagorno-Karabakh and Abkhazia in South Ossetia, for example. So, in your opinion and in your experience, which are the opportunities and challenges for the court and in terms of territorial integrity as one of the fundamental principles of the international system? Thank you very much.
La señorita, sí.
Hi, thank you for your presentation. I'm Adriana Jauregui. I would like to know how will the decision of the court regarding the boundaries between Peru and Chile, how that will affect the eventual Bolivia access to the sea if we someday get that back. Thank you.
I'll answer these two questions and then we'll take others.
Okay.
And I'll start with the second question. You should be very cautious, and I should not comment the cases which are sub judice, that means which are before the court. But not in order not to let you down, I'll nevertheless offer the answer. The court is not asked in Bolivia-Chile case to rule on the solution, substantive solution, how to grant the access. We are only asked to rule on the obligation invoked by Bolivia on the basis of a particular legal instrument, but we still have to hear from the parties detailed arguments. Next week, Bolivia submits a memorial. Chile will submit arguments and facts in February next year. These are time limits. So we have only to rule on the existence or not of the obligation to negotiate granting access, whether Chile has assumed such an obligation in the past, and whether, if such obligation exists, whether Chile has been complying in good faith, and how to comply with that obligation in the future. So if the case proceeds to the merits, because I do not know what is going to be the reaction of Chile, because as I said, when you have cases brought by unilateral application, usually in at least half of the cases, respondent first raises objections either to jurisdictional admissibility of the application. But if the case proceeds to the merits, if there is no objection or the court comes to the conclusion that any eventual objection to jurisdictional admissibility cannot be upheld and proceeds to the merits, the court may have opportunity to clarify the scope of the obligation to negotiate in international law. As I said, there are some obiter dicta in some judgments, like Gabčíkov and Aďmaros project between Slovakia and Hungary, or North Sea continental shelf cases from 1969 on obligation to negotiate in good faith. So I think this is maximum what I can say at the moment. But the boundary between these two states, we are not going to consider. That's res judicata, as determined by the court. And now moving to the first question, you know, I may have my private views on the different so-called secessionist movement or ambitions of some parts of the territories to exercise the right to self-determination, etc. But the court pronounces on these issues only when there is a particular dispute brought before it. Only in that context the court can, provided that it is jurisdiction, rule on the particular matter. So you have mentioned South Ossetia, but we did not have opportunity to consider that matter and to rule on the merits on this issue. We were asked to provide advisory opinion on whether the unilateral declaration by provisional authorities of Kosovo, Declaration of Independence adopted in February 2008, was in conformity with international law. That was in the context of advisory proceeding on request of the General Assembly. Of course, the initiative was taken by Serbia, and majority of the General Assembly voted for that resolution, although the question very much divided the UN membership, because only slightly over 70 member states of the organization out of 192 at that time. I think South Sudan was not yet member state of the United Nations, declared independence later on. Slightly over 70 states voted in favor of the resolution, but as number of those who voted against was lower, a resolution was adopted because the number of states abstained. So the resolution was passed in accordance with the rules of procedure of the General Assembly. And the court considered that act against the background of three sets of legal provisions. First, general international law. The court said something along the lines that general international law does not prohibit these kind of declarations. Then the court considered that declaration in light of the relevant resolution adopted by the Security Council 1244, establishing the provisional administration of the territory by the United Nations. Majority of members of the court considered that the declaration was not contrary to the provisions of the resolution, but that was the view of some 10 judges, or nine or 10. And then in light of the constitutional framework which was enacted by the High Representative of the Secretary General in Kosovo. So the two parts of the court's consideration opinion, that one in light of Resolution 1244 and constitutional framework, are certainly not applicable, even per analogiam, to other situations. So I think each case is case-specific, and what would be the answer, I will know the answer of the court only if such a matter is brought before the court. And it can be brought either only as a bilateral dispute, or if there is a request for advisory opinion by the organ of the United Nations, which is entitled to seek advisory opinion, like General Assembly or Security Council, or Economic and Social Council, or an international organization which has been granted the right to seek advisory opinion, basically special agencies of the United Nations. But in that, for these organizations, there is one condition, that the question has to arise in the context of the activities. That's not the condition for the General Assembly, Security Council, or ECOSOC, but specialized agencies, that the question should arise in the context of the activities of the organization. That was the basis for the courts refusing to provide the answer to the question put by World Health Organization on the legality of use or threat of nuclear weapons. But the court provided the opinion upon the request of General Assembly. So basically, the views of the court were given, but the court on the other side respected the provision relating to international organizations which have been given or granted a right to seek advisory opinion. But I would add that the court is not formally required to answer each and every request for advisory opinion, because the court has a discretionary power to refuse given the opinion, because the statute says that the court may provide. So may means that there is no strict obligation, but for the moment the court in principle all the time provides advisory opinions, because many judges think that this is the way how the court can contribute to the work of the United Nations. Although in the Kosovo opinion there were 5 members of the court who saw that there was a case in which the court could have and should have exercise this discretion.
I don't know, ¿cómo estamos de tiempo? 5 minutes? The last two questions are very short. We have only 5 minutes. Because there is a transmission for all the Americans and we have a schedule.
Gracias. Marta Lucía Ávila, de RCN Televisión de Colombia. Permítame, presidente, insistir en el caso de Colombia y Nicaragua. Colombia, para usted, está obligada a acatar el fallo de la Corte. ¿Es suficiente denunciar el Pacto de Bogotá para no cumplir el fallo de la Corte? ¿Qué piensa usted de las denuncias que se han escuchado de ex cancilleres en Colombia diciendo que ustedes se dejaron presionar por intereses económicos en la construcción de un canal interoceánico en Nicaragua? ¿Cómo reciben ustedes ese tipo de denuncias?
Thank you, Mr. President. I would rephrase my question at the beginning in English. I want to know in a bit broader sense, what do you think about Colombia's decision to denounce the Pact of Bogotá? And do you think this will have a negative repercussion on the court's jurisdiction in American states? Thank you.
All member states have the obligation under the Charter of the United Nations to comply with the decisions of the court. Article 59 of the Statute of the Court, moreover, and the Statute of the Court is an integral part of the Charter, states that the judgments of the court are binding and final. I wish to stress that the court has decided first that the sovereignty of the disputed islands, or to which Nicaragua put a claim before the court, are islands which are under sovereignty of Colombia. Then the court had to proceed to maritime delimitation because already in 2007, in a different composition, the court ruled that the 1928 treaty between the two countries and the 1930 protocol of exchange of instruments of ratification, which specified that archipelago does not extend beyond the 82nd meridian, that these two instruments have not provided and have not established maritime boundary between the two states. So in the situation when there was no agreed maritime boundary, and as I said, always it's preferable for the states to agree on the boundaries, that the court had to then determine the maritime boundary. And I tried to describe and also depict on the screen how the court proceeded in order to achieve equitable results. When you look at the territories, coasts which generate this overlap, and when you look at the final solutions and the fact that 17 judges of the International Court of Justice, 15 elected, 2 appointed by the parties, considered that this is the equitable solution, I think provide a very solid basis for this decision. The court, to all these maritime features, even small keys, accorded maritime zones of 12 nautical miles of territorial sea, yeah? Including a maritime feature which is called Quitasueño. Quitasueño consists of a number of low tide elevations. So these are maritime features which are above the sea water only when there is a low tide. When there is a high tide, they are fully covered by water. Only one maritime feature, being part of Quitasueño, which was called QS32, is permanently above seawater. Do you know what is the size of QS32? The size of that rostrum, 1 square meter. A state can use for putting maritime the base points only if there is an island. And only if in the vicinity of the island or the territory there are these low tide elevations, and this is taken into account when constructing the boundary. So this Quitasueño, QS32 being slightly or around 1 square meter in size, served as a base point for constructing the maritime area which are part of territorial sea. So you have seen the maritime delimitation on the screen, and you can form your own view whether that is the equitable result or not. But as I said, 17 judges, having studied the arguments of the parties, reached these conclusions. Well, it was the decision of the Colombian government to terminate the participation in the Pact of Bogotá. Sometimes a state may later on discover that to have a recourse to the court may be for the benefit of that state. We have seen situations that some states have rushed to make a declaration recognizing the jurisdiction of the court in order the next day to file the application instituting proceeding against another state which was already subjected to the court jurisdiction. But usually states in the declaration accepting jurisdiction formulate a condition that such an acceptance does not cover disputes in relation with states which have recognized jurisdiction of the court purposefully for a particular case, or have deposited the instruments of acceptance of the court's jurisdiction less than 1 year before filing a dispute with the court. So I respect the decision of each and every government. I just appeal all the time to legal advisors and to diplomats that court is an institution which can provide assistance in resolving bilateral disputes if these disputes cannot be settled through negotiations. And you can read in newspapers about competing claims and tensions, sometimes even demonstrating military capacity in some other parts of the world, not to create the wrong impression that I have in mind Latin American context, but in some other parts of the world, competing claims and tensions created. And so far, no agreements being reached between states.
I have one last question because it's our only concern that we have in the room. and she asked me the floor, Maria Teresa Infante, no? What? You ask?
Yes, but I didn't have a real question to raise. But my question is about a different subject. It's how much the court and members of the court rely on the media and the public information available. It's about the relationship with the world which is outside the court, not about your work, real work as a judge. Thank you.
Thank you very much for the question. Maybe in a couple of months you will have your own experience as you are now a candidate for membership in the Law of the Sea Tribunal, another jurisdiction which has the task of resolving disputes between states. Judges decide the cases only on the basis of the case file. That means on the basis of pleadings, including evidence submitted by the parties. We never study or read newspaper articles in order to get information, or we do not consider Wikipedia as a source of information. So this also provides me with opportunity to add something to the question of a journalist from Colombia that so-called plans an economic interest to build, it was reported in the press, another canal connecting the two oceans, played no role in the court's deliberation and decision in 2012. Certainly that was not the case. There was no argument presented to the court, and the court in its judgment answered all relevant arguments and considered carefully the evidence submitted to the court.
Thank you very much, and we are waiting for you in our reception.